If you've ever posted a video, written a song, taken a photograph, designed a logo, or literally created anything, let me ask you a question. Do you know who actually owns it? Most people think the answer is obvious. I made it, so it's mine, right? That's not always the case. And the difference between owning your work and not owning your work can be the difference between building a career and building someone else's. So today I'm going to explain exactly how copyright works, when you own your own content, when you don't, and the one situation that catches almost every creator off guard. Let's start with the basics, because I think a lot of people use the word copyright without actually knowing what it means. Copyright is a legal right that gives the creator of an original work exclusive control over how that work is used, with a few exceptions. That means that if you create something original, a video, a song, a photograph, a blog post, a design, you automatically have copyright protection the moment you create it and fix it in some tangible form. You don't have to file anything. You don't have to put a little symbol on it. The second you hit record or save or publish, a copyright exists for that work. Now, what does that protection actually give you? It gives you the exclusive right to reproduce your work, distribute it, perform it, or display it publicly, and create derivative works based on it. That's a fancy way of saying you get to decide who uses your stuff, how they use it, and whether they pay you for it or not. So far, so good, right? You made it, you own it, you control it. But here's where it gets complicated. There are two primary situations where you create something and don't own it, and both of them happen to creators all the time. The first is a work for hire. If you create something as part of your job as an employee, not a freelancer, your employer owns the copyright to that work, not you. You made it, but legally it's theirs. This also applies in certain contract situations where you agree in writing that the work is for hire. This is huge for creators who do freelance work, UGC, or content for agencies. If your contract says work for hire, you are signing away your ownership of whatever you create. Let me say that again, because it's very important. Work for hire means the person who paid for it owns it, not the person who made it. And a lot of creators sign work for hire clauses without realizing what they're actually giving up. Number two is assignment. This is when you transfer your copyright to someone else. It happens in record deals, publishing deals, brand partnerships, and content contracts all the time. You might create something, own it initially, and then sign a contract that transfers ownership to a label, a brand, or a platform. And once you assign it, it's gone. You don't have control of it anymore. This is what happened to so many artists in the music business. This is what the whole owning your masters conversation is about. See Taylor Swift. When an artist signs a traditional record deal, they often assign their copyright in the master recording to the label. The label paid for the recording. The label owns the recording. The artist made the music, but they don't own it. And that pattern is not unique to the music industry. It happens to photographers, designers, writers, and content creators every single day. Okay, so here's the situation that catches almost everyone off guard, and it's the reason I wanted to make this video. You get a brand deal. Amazing. The brand sends you a contract. You're excited, you skim it, you see the payment amount, you sign it. Somewhere on page 7, buried in a paragraph you didn't fully read, there's a clause that says something like, creator hereby assigns all intellectual property rights in the deliverables to brand in perpetuity. Do you know what that means? It means you just gave that brand permanent, forever ownership of the content you created. They can use it however they want, for as long as they want, on whatever platform they want. They can put it in ads, they can edit it, they can license it to someone else, and you can't do anything about it because you signed the contract. In perpetuity, that phrase means forever. Not for the campaign, not for 6 months, forever. Let that just sit in for a second. Let that just sit for a second. And here's the worst part. Most creators don't even know this happened until they see their face in an ad that they didn't agree to, or they try to reuse their own content and realize they legally can't. I've seen this happen. I watched it happen in the music industry for years, and it's happening right now in the creator economy at scale. So, what do you actually do about this? Let me give you the practical steps. First, read every contract before you sign it. I know that sounds obvious, but you would be shocked at how many creators, even just people, sign contracts they haven't read because they're excited about an opportunity. Slow down, read it. If you don't understand something, that's a red flag, not a reason to skip over it. Second, search for these specific words. Open the document on your computer, use Control F or Command F to search for perpetual, in perpetuity, assign, transfer, work for hire, exclusive, and irrevocable. If any of those words appear, stop and read that entire section carefully. Those are the words that are going to give away your rights. Third, negotiate. Most creators don't realize those contracts are negotiable. You can push back on those IP clauses. You can limit usage rights to specific platforms, specific timeframes, and specific formats. Instead of all rights in perpetuity, you can counter with usage on Instagram and TikTok for 12 months. That's completely reasonable, and most brands will agree to it if you ask for the change. Fourth, register your copyright. I said earlier that copyright is automatic, and that's true. But registering your copyright with the Copyright Office gives you additional legal protections. Specifically, it lets you sue for statutory damages and attorney's fees if someone infringes your work. Without registration, your legal options become much more limited. It costs around $65 to register online, and for any work that's generating real income, that is worth it. Here is why I care so much. The creator economy is growing faster than the legal literacy of the people in it. There are millions of people creating incredible content, building real businesses, generating real value, and most of them have no idea what rights they have or what rights they're signing away. That's the gap Girl Code of Law exists to close. I'm not here to scare you out of signing a contract or working with a brand. I'm here to make sure that you know what you're signing, what you're giving up, and what you can negotiate for. Because when you understand copyright, you're not just protecting your content, you're protecting your income, your brand, and your future. Nobody should have to learn this lesson the hard way. That's what this channel is for. If this was helpful for you, subscribe. I post every week about creator rights, contracts, intellectual property, and the legal side of building something. If you know a creator who's about to sign a brand deal, send them this video. It might save them from giving away something they cannot get back. I'm Stevie. This is Girl Code of Law. I'll see you next week.